Good evening. My name's Kaylee Rigdon, and I'm the Director of Alumni Relations at Clarke University. Thank you for tuning in to tonight's webinar, What's the Plan? Developing an Estate Plan with Confidence with Matthew Boleyn. We're glad you're here. Matthew was born and raised in Dubuque, Iowa. He graduated from Clarke University in 2008 and the University of St. Thomas School of Law in Minneapolis, Minnesota in 2012. Upon graduation and passing the Iowa bar exam, Matthew joined Reynolds and Kenline LLP, becoming a partner of the firm in 2015. Matthew has held general law practice for approximately 9 years with a focus in wills, trusts, and estate planning. Matthew is also an active member of our Clarke University Alumni Board. Before we get started, I wanted to let you know that there will be plenty of time for questions following Matthew's presentation. You can also type a question at any time by using the Q&A feature in the upper menu of the webinar screen. This webinar is also being recorded. You'll have access to all of the information shared in this discussion, and I will send you a link of the recording once it becomes available. Now I'll turn it over to the man of the hour, Matthew Boleyn.
Thank you, Kaylee. I appreciate that. Good evening, everyone. It's great to be here and to go over a few things and share some knowledge on estate planning and, of course, how to develop one with confidence. So before we get started, my inner attorney tells me I should always provide the disclaimer. Just so you're aware, nothing implied or stated in this webinar should be construed to be legal, tax, or professional advice. The purpose of this webinar is a basic intro to estate planning. It'll be approached from a very high level view. It will cover quite a bit of material in a short amount of time. And so if it's a little overwhelming, I apologize. But as it pertains to estate planning and the laws that surround estate planning, this is just a bit of the tip of the iceberg to kind of get you started thinking about what you want to do with your estate and how you want to plan that out going forward. To begin, I do want to go over a few definitions. I have provided the full definition for you on the slide. Reason being is that these are the definitions or terms that you will hear quite a bit throughout this webinar. I want to make sure that you at least have a basic understanding of what those terms are. And of course, throughout the duration of the webinar, I will repeat the definitions and circle back quite often just so we can synthesize the understanding of what we're going over. So first term is testate. Testate is an individual or one who has made a will or one who passes away leaving a will. The flip side of that is intestate. That's one who has not made a will. A person is said to die intestate when he or she dies without making a will or dies without leaving anything to testify as to what his or her wishes were or are with respect to the disposal of his or her property after death. Another term you'll hear used quite a bit is probate. Probate is a court action that deals with matter of estates and wills. Of course, probate property is property that is under the jurisdiction of the probate court. The opposite of that is non-probate property. So, of course, property that is outside the jurisdiction of the probate court. A will, which we'll talk quite a bit about tonight and get in-depth coverage on. It's a written document which leaves the estate of a person who signed the will to the named person or entities, many times known as beneficiaries, including portions or percentages of the estate, specific gifts, or creations of a trust for further distribution. Another tool that's used quite often is a trust. Trust is an equitable or beneficial right or title to land or other property held for the beneficiary by another person, known as the trustee. And finally, testamentary trust, which I'll refer to a couple times this evening, is a trust created with a will that will take effect only upon the writer's death, but is subject to the probate court, unlike a regular trust, which is intended not to be subject to the probate court. The definitions are derived from Black's Law Dictionary, 7th edition. Black's Law Dictionary is a dictionary used primarily by legal professionals as it pertains to trusts, or I'm sorry, as it pertains to definitions such as trust, wills, and other terminology used in my profession. So to get started, I'll go over probate property versus non-probate property, the division or the difference of which we'll discuss a little bit more in depth I'll give you examples of each, and we'll talk about the effects on non-probate property and wills versus trusts. Probate property, as it's defined as property that needs to pass through the jurisdiction of the probate court, meaning that in order to transfer property to the individual or beneficiary, the beneficiary is to go to, you need to utilize the court system and open up an entity, what is known as an estate. The estate, for all intents and purposes under the law, is similar to an individual. An estate is assigned a tax ID number, similar to a social security number. Claims can be filed against it. Claims can be filed on behalf of it. It can sue and it can be sued. The flip side, non-probate property that passes outside the jurisdiction of the probate court, meaning it will pass to a directed individual or entity without the use of the court system. An estate is not required to be opened if it is made up of entirely non-probate property. And this is because, and I'll repeat this quite often, but remember this, it's because that the transfer of the property is based in contract and not title. So the contract being the beneficiary designation and the agreement that upon the death of the individual, the property goes to that beneficiary. So some examples of each to kind of give you that real world application. Probate examples or examples of probate property, real property such as real estate, can be a home, farmland, essentially anything that's titled in an individual's name. The flip side is non-probate property, items held in joint tenancy, which does mean that a home or farmland can be considered non-probate property or probate property, depending on how it's titled. It also includes bank accounts, payable and death designations, and beneficiary designations on pensions and 401ks. Again, these are based on contract and not title. Question is, if we have non-probatable assets, what effects does it have on a will, which deals only with probatable property? Because non-probate assets are based in contract and not title, like I said, I'll repeat that quite often because it's very important to know the difference between the two. Will covers probatable assets that are based on title, and in most circumstances, the will not affect the beneficiary designations and vice versa. If you're using a will, it's imperative to make sure that these designations coincide with the designations of the non-probatable assets. For example, if your will states that your estate is to go to your 3 children in equal shares, but you have a life insurance policy that lists only 1 child, that life insurance policy will go directly to that child without any benefit being passed on to the remaining children, even if your will says your estate is to go to your 3 children in equal shares. Remember, this is because a life insurance policy is based in contract, is a non-probatable asset, and is not governed by the terms of a will. So, other than a will, what else do we have? And like I said, the two most commonly used vehicles for estate planning are either a will or a trust. And as far as the differences, a will creates an estate after passing as a way to transfer titled property to others based upon your wishes dictated by your will. A trust essentially creates an entity similar to an estate, but does so now while you're living. Many times these trusts are known as revocable trusts, life trusts, or living trusts. For this reason, all assets subject to the trust must be transferred at the time the trust is created, and all assets acquired thereafter must be transferred into the trust and not into the names of the individuals themselves. So when I meet with clients, for instance, I usually compare an estate or a trust to a bucket. If you're creating a will, you create and use that bucket after the passing by way of an estate. Whereas if you're utilizing a trust, you create the bucket now and transfer your assets into the bucket at the time the trust is created. So for instance, excuse me, as a real world application, my wife and I have a trust ourselves. I'll be honest, we really have absolutely no need for a trust. We would be fine with just a will. It's simply because of what I do for a living that I'm able to take the time and use my own circumstances to essentially test out various estate plans. We've had wills, we now have a trust, but in short, I'm a bit of my own guinea pig. And I say that because then I know what my clients are going through in various situations and all the pitfalls that could happen after they leave my office, for instance. We recently financed our home as an example. In refinancing our home, of course, we refinanced the mortgage, but because our home is titled into the quote Matthew and Jessica Bolin Family Trust dated June 1st, 2017, we had to sign in full our full legal names and then the phrase as trustees of the Matthew and Jessica Bolin Family Trust dated June 1st, 2017. So trusts can be a great tool, but they can also be a little burdensome when it comes to developing them and executing what exactly it is that you hope to accomplish by way of the trust. Flipping back, excuse me, to a will, which is the most commonly used estate planning instrument today, is a written document which leaves the estate of a person who signed the will to named persons or entities, also known as beneficiaries, which include percentages of the estate, specific gifts, shares of property, etc. In the next section, I'll go more in depth as to the need for a will as it relates to what happens if you don't have one and what life is like if you don't have one after you pass. Of course, we ask ourselves, well, what are the benefits or what are the drawbacks of a will versus a trust? Wills are, excuse me, wills are less time consuming on the front end. They're easier to draft. They're rather simple and straightforward. Many paragraphs in a will are standard language. Of course, we've got the language about paying debts. We've got the language about paying taxes. There's only a few select paragraphs that are based upon issues selected by the individual writing the will that actually pertain to that individual or individuals undertaking the process. They can be simple, they can be complex, but typically they involve less time to draft as compared to a trust. Drawbacks with a will. Most often wills are required to be probated, and so the length of administration upon someone's passing and costs play a factor. They tend to be more time consuming for those that are left behind to manage the administration of the estate. This usually involves working with an attorney to prepare court paperwork, filing the paperwork with the local clerk's office, publication of notice to creditors, and many, many more steps. Additionally, many states have a notice period to creditors that requires that the estate remain open for a certain period of time. By the time this period has passed, the estate's tax return can typically be filed, but at this point, several months have already passed and you're about 6 or 7 months into the process and still have about another 3 to 5 to go. In general, the administration of an estate can take up to a year. So, flipping back to a trust, if I don't want a will, or if I don't need a will, do I need a trust? Whether or not someone needs a trust is largely dependent on your financial situation, specific needs, and what you're hoping to accomplish. Like I said, my wife and I, we have a trust ourselves. However, it's not something that we would need, so to speak, but it's something that I get to play around with. And so I've ventured through that, or have undertaken that venture. When you're dealing with a trust, though, some important things to hit on. You'll need a trustee or co-trustees, and you'll need a beneficiary or beneficiaries. In most situations for living trusts, or just a trust as it's known as, the initial trustee or trustees are the writers or grantors, as they say, of the trust. And typically those individuals are also the primary beneficiary, or is the primary beneficiary, or are the primary beneficiaries of that trust. It's not until the passing of both trustees or the trustee of the trust that you would have to worry about a successor trustee. What makes a difference is that when, for instance, in my situation, if I were to pass or my wife were to pass and one of us survives, the other becomes the sole trustee and sole beneficiary of the trust. However, when that individual passes, then there's a successor trustee with successor beneficiaries. And speaking personally in my situation, the successor beneficiaries would be our 2 daughters. Successor trustee can be anybody you choose. It can be a family member, it can be a corporation, it can be a bank, it can be a credit union. Typically, they'll take over management of the trust either now or at the time of your passing or the passing of both trustees. For instance, I know DB&T here in Dubuque has a rather robust trust administration department, and they have been listed by many of my clients as successor trustees. And many times This takes place because those that are drafting a trust are doing so because of an intricate estate plan. There's quite a few investments, and it's usually more beneficial for somebody who is well versed in that area to take on that burden. There are benefits to a trust, so I don't want to speak negatively about them. They do avoid the publicity of your estate through the probate process. The probate process is a court proceeding under which most, if not all, state laws is considered public record. Although it may be difficult to find, an estate can be viewed by anyone, whereas a trust is not subject to the court system and therefore is less exposed. For instance, if you were to try or at least attempt to view a court proceeding in Iowa, Iowa is an electronic filing state. We use a program called EDMS. If you know a party's last name, a case number, and a county, you can access any of the public information in that court file, which would include, the filing of the will, the inventory of the estate, the listing of assets, who owns them, how they're titled, and of course, who is to get much of that once the estate closes. Certainly when the estate closes, the court file does not become confidential. It remains open indefinitely. And so there's quite a bit of exposure by use of a will versus a trust that should not have to go through the probate process if drafted appropriately. Another benefit, excuse me, to a trust is that you avoid court costs. The court system charges a fee to manage and close the estate for each order that's entered by a judge, and of course other miscellaneous fees as a part of the entry of certain documents and letters of appointment and so forth. Court costs are usually calculated based upon the size of the entire estate, which would include non-probatable assets. So to circle back to a will, the will covers anything that is probatable. Anything that is non-probate passes outside of the will. But as I had indicated earlier, many times an inventory of the estate must be prepared and filed with the court system. The clerk will then assess costs based on the entire value of the estate, not just those that essentially brought about the reason for the probation of the will. Another perk is the length of time it takes to manage or administer the estate, or I'm sorry, the trust versus the estate. Like I said, probate administration of a will can take upwards of a year. Length of time for trust administration is much shorter. Another key point to keep in mind is that if you own real estate in multiple states, depending on how the real estate is titled, because like I said, again, if it's titled individually, then it's a probatable asset. Depending on how and if it's titled jointly, it's a non-probatable asset. But assuming that it's a probatable asset, any property would be subject to the jurisdiction of the court in which it sits. So in other words, you could have to probate more than one estate at the same time and be subject to double taxation of court costs, as well as provide that creditor's notice in multiple local newspapers. An example would be if you own a home here in Dubuque and you own a vacation or cabin or rental property of some sort over in the Galena territories, one being in Iowa, one being in Illinois. If it was to pass through probate administration through the use of a will, you'd have to open up an estate here in Dubuque County, as well as Joe Daviess County across the river. If both properties were titled in the name of the trust, they would already be in that bucket that I had referred to earlier, and you would not have to open an estate in either state. And like I said, a perfectly designed trust should avoid probate altogether. So there's a lot of upsides to trusts, excuse me, but there are some downsides. Downsides to a trust is that there is much more work on the front end for the individual or individuals that are preparing the trust. A trust document is usually 12 to 15 pages long, where a will is usually anywhere from 3 to 6. Probatable assets must be titled in the name of the trust immediately. Sometimes there are fees associated with the recording of these assets at local county or state recorder's offices. When I say that they must be transferred, they must be put in the bucket, so to speak. And whereas non-probatable assets should include appropriate beneficiary designations, which sometimes is the trust itself, or if it works with your estate plan, the proper individuals need to be listed as beneficiaries so that whatever the beneficiary designation is for that contract-based transfer mimics whatever the language of the trust is. A trust does create a constant and ongoing need to manage the title and inventory of one's property. A small oversight can lead to the need to probate by the use of what we call a pour-over will. Pour-over will, to provide some insight, is a small will, usually about 1 page long, that essentially says, if I forgot to put anything into the trust, please go ahead, probate it by way of this will, and then put it in the trust so that way it passes based upon my wishes. The pour-over will itself is typically a best practices tool. So even though the goal or the idea of what you want to do as far as estate planning goes is a trust, we still do that as a best practices. So in short, that means even with a trust, you'll still have a will, but again, the long-term objective is not to have to use the pour-over will and not to have to use the probate court to essentially take some of your assets and tax your court costs. So one thing too that I want to go through as well is sometimes people make the plan or intend to create some sort of an estate plan, but as we all know, we get busy and things come up. And so for individuals who don't have an estate plan, the reality is everyone does, whether you know it or not. And so circling back to two of the definitions that I had gone over at the beginning, we've got testate and intestate. Remember, if you die testate without a will, you actually have a default estate plan that's set by the code of the state in which you reside. So the following are examples based upon the code as at least it's in Iowa as to what happens if you die without a will of some sort or an estate plan of some sort. Say, for instance, you have children, but no spouse. Your children would inherit everything in equal shares. Say you have a spouse, but no children, the spouse would inherit everything. If you have a spouse and children with that spouse, the spouse inherits everything. If you have a spouse and at least one child from someone other than that spouse, this is where it gets a little tricky. The spouse gets half of the real estate and at least half of the personal property at a minimum of $50,000, and then the descendant or the child would get everything else. If you have parents but no spouse or children or descendants, which could include grandchildren, your parents would inherit everything. And if you have siblings but no spouse, no descendants or parents, the siblings would inherit everything in equal shares. So circling back to whether or not a will is necessary is largely dependent on how many probatable assets one has and whether or not the state's laws provide for a distribution of the estate's assets that would otherwise be in line with that individual's wishes. Remember, though, that the state's testate laws typically do not provide for specific gifts to specific individuals. They do not provide for a designated, executor, which is the individual that handles the estate administration. And they are essentially a one-size-fits-all, and the default designations may not exactly be what you intend for as to who receives your property and who assists with the administration of the estate after your passing. All in all, I will say many times I do draft wills or estate plans that are in line with what would happen should an individual pass without a will. However, it gives someone peace of mind knowing that if the law changes, their will does not. The default designations are controlled by the legislature, and if the legislature changes their mind, essentially your default estate plan changes with it. So now you know what a will is, what a trust is, and what the benefits are, and maybe some of the drawbacks of both. The next question is, how do you make your estate plan your own? Again, this is what we call testates when you pass with a will. Some things that you might want to consider is the timing of the creation of your will. I always tell people that there's 3 points in your life where you should consider making a will, or you should modify a pre-existing will. First one being when you're fresh out of high school or you're fresh out of college. So sometime maybe in your early 20s, it's a good time to think about who it is that would get any items of property that you own. Remember, if you don't have one and you don't have a spouse, everything would go to your parents. And maybe you have certain items of personal property that you'd like to see either a friend, a cousin, or a specific sibling get over your parents. There's no guarantee that your wishes would be carried out unless you devise your own estate plan or a will at that point. The other time is midlife, maybe 30 to 40 area, when you have children, or if you have children. It's wise to do this because you'll be planning for A, if you need a guardian to take care of them, you would designate that in your will. B, if they're of a certain age, and I'll go into these in a little bit more detail in a minute, whether or not you want them to get your assets immediately or if it should wait until a certain age. Or of course, C, if there's anything you still want to go to certain relatives as by way of a specific gift to a specific person. And then of course, I always say when you're planning for retirement, I think that's another time that an estate plan should be revisited, simply because your children may be grown. You no longer need the guardian language in there. If you created a trust or certain stipulations that you cannot, or your children cannot gain access to their inheritance until a certain age, they may be above that age, and so we can kind of clean up some of the language. And of course, we may want to change who the executor designation is, as opposed to being a sibling. Maybe it's your adult child or an adult friend or close relative that you'd like to have instead. Of course, when we talk about the will or even the trust, the question is, well, who gets your property? If you have children, if you don't have children, or if you have a child that's passed but has children of their own, whether your property goes to your remaining children or if it goes their share to their children, i.e. your grandchildren. The question is, how much? Are they going to share equally? Are they going to get a certain percentage, and another percentage is going to go either to a charity or a university or a nonprofit or something else? You can do that by way of, like I said, shares, percentages, or specific amounts. Again, if there's items of specific personal value that you want to leave to certain individuals, an example is, for my wife's engagement ring and wedding ring, we have 2 daughters. One goes to the one goes to the other. Speaking a little bit to my my personal history, I'm a flute player by trade. When I attended Clarke, I was actually a music major, and so I've got my flute that would actually go to either my 2 daughters, should they decide to take that up, or in fact, it goes to another relative of mine that plays and would benefit from that. Of course, like I said earlier, if you have minor children, who you'd want to be the guardian. And of course, we do go a little in depth with this. We don't usually list 1, we list 2, or we list a backup or a backup to that. But some thoughts as to whether or not it would be a relative, it would be a friend, it would be what would be your parents or the grandparents of the children and so forth. Another type of trust that I'll touch on just briefly here is what's known as that testamentary trust, which I had mentioned in the definitions. If you have minor children, do you want to set up a trust until they reach a certain age? So say, for instance, you have a child who's 19, doesn't need a guardian, but then you also don't want them inheriting a lump sum of money at the time they're in college, whether you're concerned about how they would use it, or whether or not it's something that they would actually benefit more from if they're a little bit older and wiser. For instance, my children, they'd be 25 by the time they get their share of the principal. Until that time, though, there is language that's in most testamentary trusts that provides for what we call health maintenance and support, so that whoever the guardians are can still draw off that trust to be able to help them out financially so that they don't assume that entire burden. But of course, when they're grown, they have access to those funds to be able to use for what they choose to use it for. Of course, with having a trust, you'd have to pick a trustee. So whether it's a testamentary trust in a will, or a trustee as part, or I'm sorry, a successor trustee as a part of your trust you've created, you'd have to think about who you want that to be. For instance, I have 2 sisters. One is an entrepreneur of sorts, and the other one is in the financial industry. And so, of course, when my wife and I opted not to choose a corporate trustee, we went ahead and chose my sister that has that background and that knowledge to be able to invest our assets and to care for the long-term care of our children on a financial basis. The other thing is too, this entire process, and I always emphasize this, is that it's a team effort, meaning you need an attorney to draft the documents, but you should also be consulting with a financial planner. Somebody that manages your investments or has the knowledge about investments to know whether or not financially a trust would be a better idea versus a will. And certainly what kind of works into that is the accountant side of it, the number side. So we work with a CPA as to the management of our assets and how, if they're transferred by either a trust, a testamentary trust, or the trust we have, what tax consequences it would have on those that receive our assets and how they receive them and so forth. And so I always tell people that I know enough about the IRS code to be dangerous, but not necessarily enough to be or provide professional advice on it. And same thing with financial management. That's something that I always defer to a financial planner on. And so I emphasize that although attorneys draft the documents for the estate plan, the creation of which is very much a team effort by an attorney, a financial planner, as well as an accountant or a CPA. So we've talked a little bit about what to consider as a way of what we should do with your assets when you pass. But there are other pre-death considerations to keep in mind. A tool that is available and is many times a part of the overall estate planning package is what is known as a power of attorney. So what is a power of attorney, and do I need one? A power of attorney covers financial, legal, and healthcare decision making when either you choose for someone else to make those decisions, or at such time a physician certifies that you're not able to make those decisions on your own behalf. When it comes to the types of power of attorneys, we have a general power of attorney, or GPOA for short. This covers all legal and financial matters, everything from real estate, bank account management, retirement account management, as well as tangible personal property. The other one is the durable power of attorney, or the DPOA. That is for medical and healthcare decisions. There's three big components of that. One, who we choose to have that decision-making power when we no longer have it. Two, a living will. At what point would you want an attending physician in their professional judgment to withdraw life-sustaining support? And then three, organ donation, whether or not you want to be an organ donor or not. The big question when it comes to power of attorneys, and this also coincides with kind of the 3 times in someone's life that you would reevaluate your estate plan, because as you get older, many of the people that you may have listed when you were younger are no longer either with us, or they have their own families, or they have their own things going on. Over course, when you're younger, you may pick your parents to make some of these decisions or place certain parts in your estate plan, and then when you're older, you may actually consider your adult children. Many times when it comes to power of attorneys, the first person we list is the spouse or partner or somebody close to the individual who's granting the power to make these decisions. We typically list a backup. So in the event that that individual is not available to make those decisions, but somebody needs to make the decision now, that's typically a sibling, an adult child, or a close relative. And we can go as far down the line as you're comfortable. Best practices, at least what I say, is the rule of 3, 1, 2, and 3, but never at the same time. And that becomes difficult because if they are listed, and actually I think in most states you can't list co-agents, which is what these individuals are known as it pertains to the medical decisions, simply because they may disagree, and if they disagree, it requires court intervention to be able to address that, and many times we don't have the time to do that. So the goal, as I usually tell clients, and I know attorneys may differ on this a little bit, is to always try to avoid the probate process. Because the question is, do you always have to probate a will? Even, well, I should say if you use a trust, the goal is to not probate anything. But even with a will, the goal is still to not probate anything. This is why many in their retirement years may no longer own a home, which is a probatable asset. They may live in a retirement community, or they may be renting a condo someplace, or if you're lucky enough, you get to purchase an RV and travel the United States. And so in those situations, we would update the estate plan and review any and all beneficiary designations to make sure that no rock is left unturned. And the reason we do this is because many times individuals who still own their home at the time of their passing, the home is the only reason that we probate the entire estate, because life insurance policies, 401ks, those sorts of things have successor beneficiary designations, as well as bank accounts and those sorts of things. And so everything would pass outside of it if it weren't for the home. The example I always use is, and I have no problem talking about this on a personal level, But my parents are fortunate enough to have my 94-year-old grandmother live with them. And so I always tell people that she has a will. We've set her up with everything. But when she passes, she doesn't own a home, so we don't have to worry about that. And her bank accounts have what is known as payable in death designations. In other words, her bank accounts would be split between my mother as well as my aunt, who are her 2 children. And so upon her passing, we wouldn't have to use the probate process, although she does have a will should she decide to leave and purchase her own home. Again, court cost is another reason to avoid probate. In the unfortunate chance that you have to probate because of a trust that wasn't taken care of appropriately, or that's just the way things are set up. And of course, if you have to do it in 2 states because you've got multiple properties in multiple states, court costs and administrative fees can eat up quite a bit of that, as well as attorney's fees. I know I'm kind of advocating against my profession, but attorney's fees are much less by way of a trust administration versus having to assist an executor or administrator in the context of a will, or I should say an executor in the context of a will, or an administrator in the context of an individual who does not have an estate plan, so somebody who passed away testate. So like I said, this is a very high level view of estate planning. I know that I've hit you with a lot of information, a lot of knowledge all at once. This stuff excites me, so I'd love to go into more detail, but for fear of overwhelming you in such a short period, I'm hesitant to do that. But certainly I've really enjoyed being able to cover these topics. I hope it's worthwhile. It's provide you with some things to think about, and maybe some questions to ask an attorney, a financial planner, or your accountant as to what type of estate plan is best for you and how do we make that work. So I thank you for your time, and it's great to be here, and it's much appreciated.
Thank you, Matt, for sharing. I have a couple of questions that have popped up in our chat. So I'd like to just run a few by you, but would like to encourage the rest of the group who's in attendance with us this evening to go ahead and comment with any questions that you might have for Matthew by selecting the Q&A button. It looks like 2 little speech bubbles. One has a question mark at the top of the webinar screen. One question that came through Matthew is what the most common question that people come to your office with. So what's the most common, perhaps, discrepancy this person was wondering that is something that is commonly asked of your office that you feel everyone should be aware of?
So biggest question or most common question that I've seen is, what is a trust? Can I do a trust? A trust sounds fun. I'd love to do a trust. And I don't know why that is. I think largely it might be because of, when Steve Jobs had passed away, he had a trust. And I know there's a lot of talk about that time about how the trust was able to keep things private. It's a question that I'm happy to go over with prospective clients or clients of mine to talk to them a little bit about the differences between a will and a trust and whether or not a trust is appropriate. Typically, like I said, the biggest issue or biggest question to be asked as to whether or not you should do a trust, it really should come from your financial advisor. And so I then usually answer the question with another question and say, have you talked to your financial advisor, your financial planner about whether or not a trust is necessary? And sometimes they say, well, I don't care. And I say, well, let's do a trust because we can. And that's kind of how I got into it, is because I thought, well, I can do this. I might as well give it a shot. But trusts are nice because, like I said, it's more work for the individual writing the trust, but it is a lot less work for the individuals that are administering the estate on the back end. And so it's really a matter of, do you want to do the work, or do your beneficiaries or your loved ones left behind want to do the work? And if you want a trust, we'll do a trust. But like I said, the determination into whether or not you should do a trust or if a will is sufficient really is dictated by a financial planner.
Thank you, Matthew. Another question that has come through is, what is a delicate way, in your opinion, to approach the subject of developing or modifying an existing will and trust with aging parents?
It's a good question. And after 9 years or so, I don't know that I've got a very good answer for that. It is very common that a lot of the people that I initially speak with, it would be an adult child of somebody wanting to do that. And they say, this is what my mom or my dad or my parents have. We're at a point where I think it needs to be updated. And in many respects, it's not an issue. It's a matter of just cleaning up some language. The individual that calls me says, I'm mid 40s and they still have guardians listed in their will, or they still have trust language for a testamentary trust that says I'm not supposed to get anything until I'm 22, and they're twice that age. So it's not necessarily delicate, but I do know in many situations it can be. I've got a couple of meetings set up in the next couple of weeks where I'm meeting with somebody who essentially is or has essentially been highly encouraged to seek legal advice as it pertains to the redrafting of their trust or their will. And it largely stems from usually some sort of rift in the family. A couple of real life examples would be if you have an adult sibling who's essentially received their benefits early because their parents have had to help them out for unfortunate reasons. And so many times parents will say, well, this is going to be a part of their estate, but they never update their estate plan, or this is going to be a part of their inheritance, but they never update their estate plan to reflect that. And so, for instance, I've done some that are less controversial or not delicate, where somebody has said, my son or daughter, I gave them $30,000 for a down payment on a home, but I need my estate plan to reflect that, so that when I pass, $30,000 comes off their share and is split with the remaining 3 or 4 siblings. And most times people are in agreement with that. The only time it's delicate is when there's a sibling that has tugged on a parent's heartstrings, and the other siblings say you need to do something to correct that. And that's always going to be a delicate situation to address. I don't know that there is a one-size-fits-all suggestion as to how to do that. I think a lot of it's going to depend on the sensitivity of the situation based upon the circumstances surrounding the reason why it's being the reason why these aging parents are being encouraged to update their estate plan.
Another question that's come through, Matthew, is to clarify the role of executor.
So the role of an executor only takes place in the context of a will. The executor is the individual that's named by the person writing the will as the one who will take control of that individual's assets after they pass. In the context of somebody who's passed without a will, we refer to them as an administrator. And so they're both the same role. The question just is, was there a will or was there not a will? Under the testate laws, there's a default provision as to who is typically appointed, although it's kind of a free-for-all when you need to have somebody do that. An executor you can name into the will, and you can pick and choose who that person's going to be. The executor is typically the one that meets with the attorney. They're the ones that get what's called the letters of appointment. Those are the official documents from the clerk's office that they would take to banking institutions, that they would send to credit card agencies to close credit card accounts, those sorts of things. And so that's the person that works closely with the attorney. And in some states it varies, but more often than not, they are not represented by the attorney. The attorney represents the estate. They're simply helping that person administer the estate for the benefit of the beneficiaries. So say, for instance, there is a client of mine. She had passed and she left 2 adult children. The daughter, sister, is the executor, and so she's the one that I work with to sign the tax returns. She's the one that has signed the petition to probate. She's the one that signed all the forms that have to be filed with the court and the clerk's office and so forth.
Another question's come through the chat, Matthew. This might be from a friend, Kristen. She says, obviously, rates would vary by attorney and individual situations, but generally speaking, what are the ballpark costs of creating these types of documents, especially pre-death documents? She also says, go Clarke Flute Choir, fun times, glad you're doing well.
Thank you, Kristen. Yeah, I'm sorry, I just had flashbacks of flute choir, so I appreciate that that shout out. So it does vary, and it also varies by location. Typically, at least from my perspective and other attorneys I've worked with, a lot of estate planning documents are flat rate. And so it provides a peace of mind for the individual that's going through this process, because I never want my clients to feel as though I don't want to ask too many questions because it will cost more. And I also don't want my clients to feel like they can ask questions and they're not getting enough advice from me for their consideration on how they really want to do this. Me speaking personally from my office, it can vary anywhere from, if you're just doing power of attorney documents, depending if you're doing one or you're doing both, if you're doing the one with the living will, if you're doing a will with or without a testamentary trust, or if you're going to do a full-blown trust. Ballpark figure, it's anywhere from about $300, or I'm sorry, the individual form's about $50 to $150. You start with the wills, you're looking at about $300 to $500. And the trust is about $750 to $1,000. And of course, with the trust, there's typically added fees for the clerk or the recorder's office, because if you have property that's not in the name of a trust already, you have to refile a new deed and have that prepared. But again, that varies by location. Iowa, I will at least say this: we came back on a recent American Bar Association inquiry or survey, and Iowa is ranked 47th. Out of all the estates when it comes to legal fees. So we have some of the cheapest legal fees in the area. If you live in California or New York, I'm sorry, they were ranked in the top 5. So it depends. It also depends upon your location. Legal fees in Galena, Illinois, of course, are going to be much different than in Chicago. But a friend of mine who I had gone to school with in high school, who then went to college and law school and practices down in the Davenport area and does primarily estate planning. He said he kind of, his office adopted the same policy where most of it's flat rate.
Matt, what happens if there is more than one executor listed on a will?
So you can have more than one executor. Typically, it's 2 individuals that can work well together. If they can't, then you have to seek court intervention to make those decisions that they disagree on. Many times, if you have 2 children, for instance, and they're adult children, they'll be co-executors. In the situation I had mentioned a little bit ago, just the daughter is the executor, and that's largely because, I should say largely because, it is because some states, Iowa in particular, require that the executor or co-executors be residents of the state of Iowa. And that's more of a jurisdictional issue, because if the executor or co-executors are mismanaging the funds, they're not doing what they're supposed to be, the court has limited jurisdiction over people that don't live in this state. And not to get too much into civil procedure, but there's 2 types of jurisdiction: personal jurisdiction, and then I'm blanking on the other one. But personal jurisdiction is what the court has to have in order to bring that individual in and to shake a finger at them and say, you're not doing this right, I could sanction you. But yeah, most times you see situations where there's co-executors. For instance, when my grandfather had passed, my dad is one of 6. 2 of the 4 were listed as co-executors. Downside, though, is both have to act at the same time. And so all documents that need to be signed by both of the executors in most situations. And so if you've got one, say, for instance, that lives in Dubuque, and you've got one that lives in Waterloo, there's a turnaround time to get a signature from the individual that lives in Waterloo. So for simplicity's sake, we always recommend one, but the reality of it is it happens quite often that there are 2 of them.
Can assets in a living trust pay for medical expenses or long-term nursing home care?
So not only can they, I want to say in most situations they have to. And that's usually because before, and I don't want to get overly specific because I don't want it to be construed as though I'm giving legal advice, but the way it works, at least in Iowa, is that there is a spend down provision of certain assets. And even if assets are in a trust, if the beneficiary is the sole beneficiary of that trust, then they technically have a legal interest in those assets, which then could disqualify them for state aid. And so they wouldn't qualify. I apologize, I get Medicaid and Medicare mixed up, but I want to say it's the Medicare that essentially says, well, we're not going to provide you with any funds to assist you in your nursing home expenses until such time you've used up all the funds in that trust. For instance, I am a trustee myself of a trust. It was a court appointment. It was, long story short, the court had to become involved because there was some mismanagement by the previous trustee. But in any event, that individual will have to use the funds of the trust just because of what she has access to before the state will provide any sort of aid when she enters or if she enters a nursing home. So I guess to answer your question, not only can they, but they, in most scenarios, would have to be.
Another question, Matthew, is asking if a person has to have a minimum amount of assets to create a will.
No, a will can be created with anything. I mean, you can create a will, and if there's no assets to probate, that's not a problem. Then we just don't probate the will. If you have assets, depending on their size, really brings into question as to whether or not it's financially viable to probate the will. For instance, if somebody has an estate plan, but they don't own a home, but they do have something titled in their name that has to be transferred or that you have to gain access to by way of opening the estate, by the time you pay court costs, attorney's fees, file the tax return, and so forth, it may not necessarily be worth your time or financial benefit to process the estate. And so there's no minimum, although it just may not be financially feasible or viable to transfer that out of your estate by probating the will at some point.
Those are all of the questions that I have in my queue, but if you're anything like me, if you're listening in on this webinar, your questions are probably going to come later. Usually about 9 o'clock at night is when my brain starts moving very quickly, and that's when all of my questions come through. So Matthew's kind enough to share his contact information with all of you here on the screen. I would encourage you to write down his email address, which is bolin@rkenline.com. And he's more than happy to answer any questions that might come up at a later date and would definitely be happy to meet with you virtually to discuss your own personal matters. So thank you so much, Matthew, for leading this important conversation and for sharing your expertise with us. Tomorrow, all of our participants will receive access to the recorded version of this webinar, as well as a very short survey. I invite you all to please fill out that survey so we can continue to offer quality webinars and virtual events to our Clarke alumni and friends community. We'd certainly appreciate your feedback. We hope you found this helpful and hope that you'll join us again for future webinars and virtual events. Our next virtual event is coming up fast. Clarke Day will be held from noon to noon on Wednesday, March 24th and Thursday, March 25th. We hope you will join us in celebrating, connecting, and supporting all things Clarke on our 7th annual Clarke Day. Thank you again for joining us. Have a wonderful night.